The family that vacations together stays together. At least, that was the plan. Except now, the dastardly desk clerk is saying he can't confirm your connecting rooms.
Wait, what?
That's right, ma'am. You have rooms 201 and 709.
No, we cannot be 5 floors away from our kids.
The doors have double locks. They'll be fine.
When you want connecting rooms confirmed before you arrive, it matters where you stay.
Welcome to Hilton. I see your connecting rooms are already confirmed.
Hilton, for the stay.
Every story you love, every invention that moves you, every idea you wished was yours, all began as nothing. Just a blank page with a blinking cursor, asking a simple question. What do you see? Great ideas start on Mac. Find out more on apple.com/Mac.
Hello, besties. Special happy hour episode. Oh, gosh. Are we excited or what? We've got some updates, don't we?
We do have some updates. Jamie, do you know what we have an update on?
I think we're talking about SHRM today.
Yeah. Well, we're really talking about why HR is important.
Yes. Yes.
Why it matters to keep you out of bullshit like this.
Good HR.
Good HR.
Good HR. Best practices should be something that do more that live on a website. They actually come to life. And it doesn't always have to be best practices, but it should be decent practices at least.
Decent.
Yeah.
Non-litigiousy causing practices.
You all know this, having been a lawyer, having been in litigation, going through the SHRM lawsuit in particular, is I told the ladies, on one hand, it's very hard because I no longer practice law and I don't really want to, but it does bring me back to going through PACER and these federal dockets. And that's the website where you can go and access so many things. So you can kind of see what's going on behind the scenes. And oftentimes it's just regular court documents because there's a lot that's exchanged between two parties in a lawsuit that you don't normally see. But when parties start having some disputes and keeping stuff out, you start to get a peek on what's been going on over the last few years. And we've got that today. And something extra special or interesting towards the end of the episode.
Ooh, juicy. Lawsuit BTS behind the scenes. Ashley, our resident legal experts, fill us in.
Just to set the stage again, so SHRM, Society for Human Resource Management, is being sued in federal court by its former employee. And this employee was terminated from employment over 5 years ago. And only now is it set for trial, just coming up in a couple weeks in Colorado federal court. And so these things take a long time. And this is all about race discrimination of this woman who's an instructional designer. So she was designing courses and working on that SHRM would, sell to the public. So she was let go from employment, ostensibly for missing a deadline. And the whole case is about whether that was really the reason or whether it was driven by race discrimination. And that happens with a lot of cases in the US, like race discrimination, harassment, retaliation. Those are the types of things that people can sue for. Because generally in the US, you can't just sue like
if someone's an asshole.
Yeah, you can. It's, I've heard sessions where lawyers are like, you can be an asshole. You just have to be an equal opportunity asshole. It's like, well, let's just not be either.
Yeah, it's not illegal to be an asshole. I think Leigh said that one of our episodes.
Mm-hmm, sadly.
It should be. But here in the US, things generally have to be tied to some sort of protected class. But so anyway, this lawsuit's been ongoing. And so part of why this lawsuit is so unusual is really two reasons. One, as mentioned, it's going to trial. That so rarely happens in employment lawsuits. Oftentimes these things that's when people sign severance agreements before, if they're let go, like before things ever get to a point, or you file an EEOC charge, you file a lawsuit, all those things. But so here, and there's a point that the judge has the opportunity before this would ever go to a jury, where the judge can say like, no, one side wins without even having a jury trial. But here, this is one where we've talked about this, I won't repeat it, but the judge had said this is a messy employment discrimination case, said that in writing. First sentence of his order sending this to trial. Because SHRM had asked for this to be dismissed, before a jury trial. Not only did the judge say no, I think that there's things that a jury needs to figure out what was really going on from a fact perspective. But the judge had also said SHRM may be liable for punitive damages in this case, which means, people are like, how much really happens?
Cha-ching.
Well, and this one's interesting, and this is like, I'll get to the more interesting things. But in the US, you hear about Title VII. Like Title VII is the kind of the employment law, federal employment law that has different protected categories. This lawsuit is really about Section 1981. And there's like, what's that? You can look it up. But a big difference between Title VII, if you sue for, because you can sue for racial discrimination under Title VII, but Section 1981 is just about race discrimination. Title VII has caps on damages. So there's like maximum caps that you can get. 1981 does not. So there's a lot more money potentially at stake. So that's some of the behind the scenes that's interesting here. But I'll just talk about a few things that have happened because so this case is set for trial. And what happens as you get closer to trial, they had a settlement a couple weeks ago. That settlement was not successful. We'll explain later how we know that. But also in addition, parties are still going back and forth filing motions. That's how anyone can figure it out on PACER. But what's happened in particular is there's been some like discovery disputes and motions because there's motions in limine. We've talked about this a couple weeks ago. As you get closer to a trial, parties are like, hey, don't talk about this. Do this. Well, there's one in particular that's whether SHRM can introduce something that is, not unusual. Like, have you all ever had exit interviews at work?
Yeah.
Mm-hmm.
Conducted them as HR, maybe had them yourself.
Conducted them. Many.
So this has come up because in the lawsuit, so again, this is a woman who's suing SHRM, and there's all sorts of things you have to prove, or and SHRM has to go back and forth. But her claim is that she was treated differently because of her race. And in this case in particular, the boss over this department had 4 direct reports. 2 direct reports were let go from employment about 5 years ago, actually, like just within a couple weeks of each other, like a month of each other. Those were the 2 only Black employees on the team. So already, like, again, this has been brought up as well in some of the documents. And so those that are in HR legal are like 2 within like a 1-month period, both for ostensibly performance-based reasons. Like, again, that's something that tends to not weigh in well in an employer's favor. But also that's unusual in this case is that the plaintiff actually got a declaration. So this is like a sworn statement. And the sworn statement was actually from a white colleague who filed a statement saying, literally, I'm reading from it, I observed the boss treat the plaintiff differently than me and my other white coworker throughout my employment with SHRM. And that's how it starts. So this goes on to give examples of things of like this boss disparaging the plaintiff's abilities, referring to her all these ways, and that the boss's tone was aggressive with the plaintiff in ways it wasn't with others, that this white colleague missed deadlines. And this is really notable because, again, SHRM's reason is that the plaintiff didn't meet these deadlines. And the plaintiff showed that she had submitted these 2 courses by the deadline. SHRM's like, well, they weren't enough. This person who did the affidavit finished them and had said it really didn't take, like I think she said it took a week or 2, but there's just a lot of things back and forth. And so some of this is just knowing the things that happen in employment, those conversations, using these tones, whether you treat people differently or other people say that you treat people differently. These things don't just happen, and they don't just happen, and it's not just a risk of those coming on Glassdoor. But so this person has filed this like legal statement, paragraph by paragraph, that's now public about this. Because also in it, this person who did this affidavit, again, this colleague, and she talks about how she actually raised internally concerns about the boss and how she treated this colleague, which having someone speak up for you during employment, that she was speaking to other leaders and had participated in discussions with HR, for example. But so one thing that she says in the affidavit is that she had shared that in part of her reason for leaving is that she believed that the boss is racist and because of what happened to the plaintiff. And that's what she said in her exit interview. The person who had her exit interview said that SHRM was aware that it all had been reported. And this is all in this, like, again, this is like a publicly facing document. So this is me. I have nothing to do with SHRM or anything. Like, you can pay 10 cents a page and go get these things. But SHRM has now said what they want to introduce was a recording of that exit interview.
What?
Now, I was like, what? Because have you ever like knowingly recorded an exit interview?
Absolutely the fuck not.
No. Record nothing like that in the office. Nope.
My mouth is agape.
No. Do they even on their website, do they even recommend that on their website, recording? You know what I mean? Because don't do that.
But the wild thing is, and the reason I know about this now is because often things like these back and forth, like the declaration, would likely be part of it. But so SHRM's saying, well, in the exit interview, she doesn't say what she said she did in the declaration. And so that comes up to saying they're like, this back and forth. But the wild thing about all this is that things with discovery, so like before someone files a lawsuit, they often have a lawyer letter, and the lawyer letter goes to the employer and they're like, hey, preserve everything. Don't delete things, and, preserve everything and turn things over to us. And then in the discovery process, the lawsuit goes on. They're like, okay, now it's time for you to give us all the stuff you've been holding in a nice little tight basket. September 2020, plaintiff's fired. The charge was filed, I can't remember the exact dates the charge was filed, things like this. Anyway, lawsuit was filed in 2022, mid-2022, so it's been ongoing. The lawyers for SHRM only produced this recording of the exit interview in June 2024. So like lawsuit's been going on for 2 years.
Why so long, SHRM?
I don't know, but so there was an exit interview that she'd had with this like big boss. And so SHRM's lawyers are like, we want you to retract this whole declaration. We want all these things. But also in the declaration, like one of them, the point where she says she made the statements is not the person that the recording was with. So I don't know if it's like 2 exit interviews or whatnot. But anyway, the point is SHRM now has said that they're going to play this recording of this exit interview, or they want to have that available at trial. So the lawyers for the plaintiff are like, well, no, you didn't produce this during discovery, X, Y, and Z, all these things. But anyway, the takeaway is they have a recording of exit interviews? To me, that was wild.
Yeah, I've never heard of that.
No, not a best practice. Why do you want to keep like creating material for discovery, especially when you don't know what you're doing as an organization?
I don't know. Like as the plaintiff's counsel says, and again, in these emails back and forth that are now part of all this production and attached to things, like the plaintiff's counsel is like, I find this disclosure. So this was 10 months after discovery had even closed. They're like, I find this unfathomable.
Agree. Why so long?
And this isn't even the craziest thing of all that. It continues.
No, this is not the craziest thing. This is just such an unusual case. I haven't hardly ever, and I've done a lot of, I was involved in a lot of employment, litigation things. And I'd never seen something, one, where you have a declaration from like a white colleague about, how I spoke up during my employment for a Black colleague.
I've never seen that.
So I say, like, I'd made, this longer video a while ago talking about these things and just how it's important to follow these things. Anyway, but so SHRM has this exit interview recording. So the parties are going back and forth. So as of the date we're recording this, which is Friday, October 31st, happy Halloween, the judge hasn't publicly announced whether he would allow that audio recording in or not.
Quick update. On November 4th, the judge in the lawsuit denied the plaintiff's motion to keep the exit interview recording out of the lawsuit. So this is a win for SHRM. But this judge seems to have had enough of this case already, even before trial, because in it, he repeats the same line that he had in his order sending the case to trial a year ago, that this is a messy employment discrimination case.
Attention, pet lovers. You will love this. Because us HR besties are all in on holiday cheer. And of course, our pets are too. Well, when they're not snoring while we're trying to record our holiday episode. But we love our pets just like you do. And that's why we're joining Chewy Claus, who's out here making pet wishes come true. From November 4th through December 24th, you can share your pet's wish at chewy.com/ChewyClaus. It might actually come true. And every wish helps pets in need too, because each one triggers a donation of 5 meals to shelters and rescues across the country. You can submit through the Chewy app, and Chewy will double that donation. So you can share a wish for your own pet. Or if you work or volunteer for a shelter, shelters and rescues can join by submitting your own wish list, and then people can find it and donate items. So go check it out and share your wish and help others along the way. Because we all know that our pets are the real HR department at home, and they definitely deserve a little extra joy this season. I love Chewy, and I'm going to make a wish, and I hope you will too. Every pet deserves a wish come true. So send your pet's wish to chewy.com/ChewyClaus, and it might become a reality. Plus, your wish means that Chewy will donate 5 meals to pets in need.
PSA to all our HR besties living in their strategic partner era. This one's for you. If you're tired of pulling metrics from 5 systems and still feeling like the data doesn't add up, you need HR Bench. It's the people analytics platform built for HR teams who are done with busy work and ready to bring the good stuff to the boardroom, like predictive turnover data, diversity benchmarks, span of control, rookie ratio, and all that juicy insight that makes you look like the genius you are. No IT drama, no 47-tab spreadsheets, just instant access to real-time HR metrics, plus a custom benchmark report if you book a demo at hrbench.com. Mention HR Besties for 10% off an annual plan and tell your execs their new favorite strategist is you.
One other thing, just from a behind the scenes, to give a sense of what employment lawsuits are like and why you do not want to get involved in them if you can avoid them. And it's not just to avoid liability. Again, as you go through, and I've read so many pages of this, these depositions and all these things, just to get a sense of what goes on here. And it's so instructive for so many employers, because you just read it and you think like, I wouldn't want someone treated like that. Someone I know, I wouldn't want to be treated like that as the plaintiff. And, we'll find out what happens with legality, but it's just the thing I always had a really, really hard time with being an employer side lawyer. And I had some cases where I was working on the employee side, but employer side was like, it's like when you're in an auto accident, you have the little thing that's like, don't apologize or whatever. Like insurance companies are like, don't say you're sorry because we don't want to be liable. And you're like, okay, so you hit someone and you can't be a freaking human. You feel like that sometimes in these contexts where like the lawyers are back and forth and there's so much of like, and again, whether it's illegal, like you don't treat people so poorly in the workplace. And when you do, it can cause risk. And so our point is in this as well is treating people like humans isn't just good because you'll avoid legal bills. It is so important, and people don't need to feel dismissed or like their job has been taken from them when they're speaking up. So in addition to like in a lawsuit where you have to go back and forth and rehash someone's employment, you're going through emails, you're having things that you wrote put up on screen. You are having people on an HR podcast that are reading through those and talking about those. But also you have to start getting into other people's things because part of discovery, and again, a lot of times with discovery, which is information, isn't made public. But in this, because of some discovery disputes and other things and motions in limine, some of SHRM's responses have now been public. And so one of them is a time when plaintiffs said, okay, how many employees were terminated for performance from January 1st, 2015 to the present? For those that have had to go through any sort of discovery thing and go through, it is like so cumbersome to go through and you're trying to figure things out and go through records and all this. So SHRM, has all its normal objections and things like this, but they go through and they're like, here are employees, and they're like, we're going to produce from January 1st, 2020 to the present, whatever, like everyone, goes back and forth with the dates. So they've listed out 28 employees. So this is like public documents. It lists out their name, their position, their manager, and their department, and says these are employees terminated for poor performance. Which again, I don't know SHRM's total employer size, but just knowing these are the things that happen in lawsuits. You have to go and not only find this information, you put it out there. And my guess is, and what can happen is some of these, employees that, obviously we're not going to cite anybody's names, but people may look at that and be like, what? Terminated from employment, like for a poor performance, like, oh, that's not what I was told. Like that's, again, not knowing any of these circumstances, that's what tends to happen. And so it's just, all of this takes up so much time and energy.
Oh, ick.
What was the time frame again?
Like 10 years, right? Ish.
SHRM has these objections like what matters, what doesn't. So they said January 1st, 2020 to the present. And so this was within a basically 3-year time frame because it was January 3rd, 2020 through December 29th, 2022. So it's about 3 years, 28 employees terminated for poor performance.
I believe they have around 400 employees. If you do the math, I mean, it seems like a semi-substantial number.
Of course, they don't put race on there, right? That'd be interesting.
Nope.
Like if it's 50% people of color, but their total population, people of color is like 5%, like that would be interesting.
They don't, but interesting. And they've listed it by termination date. And these are the things that, like, again, having been in the world of lawyers, people will be like, how should we present this that makes us look like
decent? Yeah.
I'm a little surprised, but maybe not, because right next to each other on this chart are the two African-American employees who reported to the same boss who were terminated less than a month from each other. And so if it's me, I could see people being like, oh, maybe we should do it alphabetically.
Spread them out. Yeah.
And these are the things that lawyers tend to, like the lawyers that are getting paid like now, like $1,000 to $1,500 to sometimes more dollars an hour are spending, billing clients talking about like, what order should we list these to make us look? And so again, it doesn't list any of that information. Anyway, it just goes to show like when you have these lawsuits, it goes back and forth, other people get involved. It's just, again, we talk a lot about terminations for performance and everything like that there should be so many conversations before you're getting to the point of terminating someone for performance.
Mm-hmm. There should be, unless you are racist. And it was a biased term that is illegal.
That too.
And, you know what I'm saying?
That can certainly happen as again, searches of other headlines of other employment cases can show you, certainly has happened in other situations.
And I think a lot of times too, like when people are put on a performance improvement plan, a PIP, a lot of times people like resign too. At least in my 21 years since I've seen a lot of people. So then you kind of wonder like how many resignation, like
were really targeted and, and
Yeah.
Of course. And again, these are the type of questions that often end up. So this document's produced and then you go into a deposition and people are like, okay, let's walk through all these different things. What happened? So you're trying to rehash these things and whatnot. And in this case in particular, again, the plaintiff that was terminated from employment was not on a performance improvement plan.
Also an issue.
Mm-hmm.
Just to keep in mind of behind the scenes, you get into things of having, you may think something's all fine and good, but you never know who's going to come up with a declaration about what they thought. They're raising concerns about things. You see things rehashed. But also, as you get closer to a trial, you have to prepare for the trial. And so, those that have been to jury duty, you may know that you sit down, although people start asking questions. Sometimes it's like the normal questions, especially if it's like a car accident type case. Who's your insurer? Stand up, do your name, name this. No fun facts, sadly, in jury duty. But what you may not know is those questions. It's very similarly, oh gosh, I just thought of this. So Devil Wears Prada, great movie, obviously. Remember when she's like, cerulean, you think you just chose this sweater, but this sweater has been carefully chosen from you by, this fashion, whatever. That's what those questions are like in jury duty. They are the cerulean sweater because those questions have been carefully crafted by each side's attorneys and the judge deciding what's going to be asked. So the first step of that has to be the different parties asking what questions they think should be asked to get the right jury. And that's called voir dire. But so each side had a deadline, and this went on the PACER docket as well, of the questions they wanted to see. And the plaintiff's questions, like I think they had 7, probably not surprising, all about like, have you ever been discriminated against? Have your relative, things like that. And these questions are really designed because and there's federal rules and all this stuff in court, but it's designed because sometimes there's automatic strikes. Like if someone's like, I know the plaintiff personally, the judge is probably going to be like, okay, you're not coming in. But there's other ones where you can kind of get a feel, and this is where the sides are trying to predict how they'll, what a juror will think. So they ask the questions to get a sense of that and who they want to strike. So plaintiff's pretty normal. SHRM had its voir dire questions. SHRM had 32 voir dire questions, but really a little more because like one or...
They were like multiple questions. Yeah. 5 questions.
Some of them have like 2 questions in them, like, oh, if so, what was, this, or two part B with the question. Yeah. So we're in the mid 30s, getting a little towards 40. Anyway, all these questions. And so I started going through these and I'm like, oh, okay. So here are 3 in particular that stuck out to me, and they're under categories. So under the category of views on employment, fairness, and management. Again, that's SHRM's lawyers are putting this. How important is it to you that HR follows every best practice step before termination?
Coming from SHRM.
Well, if I'm going to be terminated, pretty damn important.
Coming from the people that are leading HR professionals to make
termination decisions
by best practices.
They're creating processes.
The irony.
It's not lost.
How do you say like no to that? Like, how do you say?
I don't know.
You just say no to that question.
Right? Is the sky blue? I mean,
and again, you kind of surmise that the reason behind that is, again, as you go through and like the judge's order really succinct. Like if you're only going to read one thing, if you go and look at like judge's order, sure, you can read it, and the judge points out these things and that's part of the reason the judge says that they're put potential for punitive damages, in particular because of the way this was carried out. So I think a very certain argument that the plaintiff will be making is that there were not best practices followed. But so anyway, one question that's interesting to say, like, who's going to say no to that question?
Wellness benefits have come a long way, but many companies are still managing a program that consists of not much more than a gym membership and a few one-off perks. Not everyone defines wellness the same way, right? Some people need therapy. For others, it's meal delivery because after a long day, they can't even think about cooking a healthy meal. It could be a massage, home gym, or a meditation app that helps them reset. And me, gosh, all of the above, emphasis on massage. Well, Comp makes that all possible. With Comp, you can give your employees access to a personalized wellness budget. You set the controls, the budgets, how often they spend, whatever doesn't make your CFO have a heart attack. Then, your employees get to decide what wellness actually means for them. It's simple, flexible, and exceptionally easy to use, which is why Comp sees, on average, over 90% adoption. When employees feel genuinely supported, you can see the impact on retention, engagement, and reduced burnout. A flexible benefit program is one of the clearest, highest value ways to show that you truly support your people individually and holistically. That's why Compt is rated 4.8 stars on G2 by HR leaders like you. If this sounds like something you needed yesterday, head to comp.io/HRBesties right now to connect with the Comp team. That's compt.io/HRBesties. Who's excited for Black Friday this year? I know I am. Can you believe it? Oh, it's already that time of year again. And everyone knows that the holidays can become overwhelming quickly. So the sooner that you get things done, the better for both shoppers and businesses. The best time to score great deals are during the holidays. Well, Shopify is the commerce platform behind millions of businesses around the world and 10% of all e-commerce in the US, from household names to entrepreneurs who will be participating in their very first Black Friday this year. Do not let your brand's voice get lost in the thousands of messages consumers will be seeing. Shopify's marketing tools will help push your brand to the forefront of the chaos no matter what platform your customers are on. You can also stress less, knowing that Shopify's award-winning customer support team is on standby 24/7 to help with any issues that arise, allowing you to get back to business as fast as possible. Don't have time to spend hours poring over every little detail? Well, Shopify has thousands of templates and tools to help streamline website creation, making sure that your site isn't just aesthetically pleasing, but functional at the same time. This Black Friday, join the thousands of new entrepreneurs hearing for the first time with Shopify. Sign up for your free trial today at shopify.com/HRBesties. That's shopify.com/HRBesties. Go to shopify.com/HRBesties and make this Black Friday one to remember.
Another one that is a little interesting is under the section called Views on Discrimination, Race, and Retaliation. Question 19. Who thinks employees need to be protected from mistreatment by their employers, businesses, or corporations?
Another no shit answer.
I mean, they're just trying to load the jury with masochists or what?
Yeah.
Idiotic masochists? I mean,
I think I mentioned last year I was a potential juror for an very crazy employment case that I didn't make the jury panel for, and partially because I had to answer yes to every question. I'm like, have you ever investigated something? I have, but I was very interested in it. But if I'm sitting on the jury, again, if someone asked me that, first I would be like, I would be quiet for a second. Protected for who thinks they need to be protected?
I'd be like, can you repeat the question? Did I hear that correctly?
Yeah, what? I'm sorry.
Right. Can I ask if do you mean does mistreatment exist? Or do you think that if mistreatment's happening, they shouldn't be protected?
Interesting.
Yeah. So it's those ones of if you're on the jury, how's that going to? But here's the one that I saw this in my eyes popped out of my head. 16. Do you personally identify with the motivations of people who participated in any protests or demonstrations that took place due to George Floyd's death?
This infuriated me.
What's the point of that? Do you support Black Lives Matter? That's what they're trying to say.
Yeah.
Are you racist?
So if you don't, then I need you on my jury. Is that what?
What are they getting at?
I don't know. Some of these, this is just the behind the scenes of these things. And there are lawyers that will be putting these together. And again, this can be law firm lawyers, no idea if SHRM's sitting there in the room thinking about these, or this is just the law firm's lawyers doing these. Some of your questions come from a template. And calling it George Floyd's death as opposed to George Floyd's murder.
Mm-hmm. That's intentional.
Mm-hmm.
Some of the background of this. So the plaintiff was terminated from employment in September 2020. So this was, just in the months after George Floyd's murder. And there were discussions in some of the, I had gone back even to the plaintiff's deposition. Was there a claim that she was taking time off to go to protests or things like that? And
how does it tie in? Yeah.
Yeah, no, some of that scene, as her raising her claims, she felt emboldened. I can't remember the language used, but more emboldened in the heels of George Floyd's murder. But,
anyway,
again, just trying to imagine being on a jury where this question comes up.
I wouldn't be able to hide my face because I can't anyway.
No, I wouldn't. Or my mouth, for that matter.
I'd just be like, wow, what?
I'd be like, the fuck?
Who, what, where, when, why, and sometimes how.
So what happens in these is, again, the parties submit what their proposed voir dire questions are, and then the judge, ultimately they'll come together and decide what they're going to be. Judge will, is the ultimate decider of these things. But so these are what recommendations are. The judges, they're probably not going to have 50, 60 voir dire questions, but it'll be fascinating to see what comes up. But so as we've been following this, one thing that happens periodically as well, in addition to voir dire, is some of these pretrial conferences, things getting ready. Like, okay, let's get ready. All these things, talk about these motions in limine. And again, one motion in limine that had come up was SHRM not wanting any reference of its expertise in human resources.
It's its whole business, but okay.
Like, okay.
Partially, one of the things SHRM wanted to do is they wanted to separate out the trial into two parts. First, whether they're liable, then whether it'll be punitive damages. Part of that is because some of the potential evidence for punitive damages would be more about like SHRM's best practices and things like that. And so the judge's like, no, we're going to have all the trial all together, and also about their expertise and things like that. SHRM wanted to have that motion in limine that there could be no evidence brought in. The judge had said, kind of very briefly, that's not necessarily denied for now. Like he's not going to bar any mention of that because it could potentially be relevant for punitive damages for things. But again, it depends. Like you can still make objections and all that during trial and get closer. But part of the reason that we know what the judge said in this hearing is because if you go to PACER and see that there was a hearing and they talk through things, this transcript is not on PACER, but what was on PACER was like talking about how there's a hearing, grant, deny, these things. What was on PACER is a note that said that the lawyer for SHRM orally made a motion for a gag order pertaining to communication with the press.
Can I please read that part?
So what happens? So what happens in that is, of course, PACER me is like, wait, what? And so, can you get a transcript of this hearing? Like, what do you mean orally made this motion? What's that? And you can, in addition to paying for PACER, the member of the public or the media, like a podcast, you can order a copy of the transcript and find out what was said. Because I was like, a gag order? Who's been talking to the press? And the answer is, SHRM thinks lawyers may have been talking to certain HR podcasts. So, ladies.
Can I read that part for real?
Sure. So we have this transcript that we got of the hearing. And I tell you what, I've read a lot of transcripts of hearing, but I've never read one where we appeared as a podcast.
The judge says, "What's the defense got?" The defense says, "Thank you, Your Honor. There is one issue because just yesterday we became aware that plaintiff's counsel has been speaking to a popular HR podcast who has been covering this case in a manner that basically disparages SHRM and their position. In fact, during a very recent episode on this podcast, which specifically attacked proposed voir dire, did I say it right?
It's close. You're good.
Voir dire? All right, good enough. Questions submitted by defense counsel, the host clearly indicated that she had been in communication with plaintiff's counsel. To quote, she said, "The parties did have a mediation last week, but we've confirmed with the plaintiff's counsel that it is still scheduled for trial, so they are in communication. And so as such, it is clear that plaintiff's counsel is communicating with the media about this case, which is only part of the problem. The pretrial publicity is targeted. It's designed to shake the perception of SHRM's defenses as it goes into great detail about our motions and limine topics, specifically our voir dire questions. The host of the podcast openly criticizes SHRM's strategies and compares them with those of plaintiff. Also troubling is assessing whether to issue a gag order, Your Honor, which is what the request is from the defense. We realize that it's a big ask, but the court should consider whether there is reasonable likelihood that media attention or extrajudicial commentary will prejudice a fair trial. And we believe here that is the case." And it keeps going.
I can add a little bit here. Jamie, you want to start with line 10?
Yeah.
This is still from the transcript.
Now to give some context, this podcast, two of the podcasters, Leigh and Ashley, have indicated that they plan to attend the trial every day, live. They're called and they have 1 million downloads. Yeah, that's us, by the way, guys. They've communicated on TikTok, Instagram, LinkedIn, and what's troubling is the misrepresentation of facts and the skewing of facts. That is very, very troubling. They're clearly talking to the plaintiff's counsel. And there is a clear bias here against SHRM. And that is just troubling. And we want to bring that to the court's attention.
Ooh, there's some things to respond to in that, isn't there? I know Ashley wants to.
Well, I was reading this and I was starting to, but I didn't even have to because the judge, he said, well, we'll turn to plaintiff's counsel in a moment, but he's like, you may not know the full answer to this. But at least the only thing I specifically heard attributed to plaintiff's counsel was a statement that the matter was still set for trial. And it sounded like that was the only piece delayed. I talked to this person, they told me whatever. Like, was there any other specific attribution? The lawyer for SHRM said, what I confirm, it's very troubling. What jumped out was the attack on voir dire, because the voir dire process itself is attack. It cannot serve as a safeguard against prejudice. That was just really troubling, Your Honor. But yes, that's all I can communicate was, the case continuing.
Troubling, troubling, troubling.
So the court's like, all right, let me ask plaintiff's counsel. So plaintiff's counsel, must have had that. Must have just had this ready. She's like, yep, Your Honor. One of the hosts of that podcast did reach out to us last week, and she emailed me and asked if the lawsuit had been resolved or was still proceeding to trial. And I responded, hi, Ashley.
Just to hear your name.
It's been a minute since my name has been in a federal court transcript. Hi, Ashley. Thank you for reaching out and for your ongoing interest in the case. As of today, the case is still proceeding to trial the week of November 17th. And that is the extent of our correspondence with these folks. And they're like, all right, anything else to SHRM's counsel? The judge is like, no, nothing else. But so the judge talks about things. And one thing the judge gets into is like the legal equivalent of it's not that deep. Like, I know, SHRM, you probably don't like this. And so first the judge is basically like, a gag order, I've had cases that have had national publicity and we've still been able to say to a jury just fine. We're good here. They're also like, this case is publicly available. Anybody who wants to pony up the money for a Pacer account can see it. And then said, I take it at word the plaintiff's counsel's response was limited. Like, this seems to be totally fine within the rules of civil procedure. I've heard nothing else and I hear you. But so denied the gag order and ended there. But I did not expect, of all of our coverage of SHRM, and again, our coverage is because this is SHRM. This is notable. It's SHRM. SHRM touts itself as the expert of all things work. But I did not expect when I got this transcript.
Wow.
Oh,
I made t-shirts, y'all.
I love it.
Let's see, how many times does the word troubling show up in this transcript? Six?
Ooh.
6 times, because we're troubling.
All in the same section. To your point, Ashley, I love when the judge says this. He's like, and this is not in any way to disparage or diminish this case, but when I look at this case in comparison with others that have received extensive nationwide media attention, and there are many of those, we are able in those cases to seat a jury. We are able to find 9 or 12 jurors, as it may be, or more, that have read and seen nothing about the matter. And we are able to prophylactically insulate them from the matters during the course of trial. I love prophylactically insulate for real.
Well, could you think of that word on the fly? I don't think. If you were to search the transcripts of all of our...
No, because I just think of like a condom.
Yeah. No.
Yeah, that's what he's saying.
I learned of that word 100% from a Snoop Dogg song I'm pretty sure back in the day. Like, I'm pretty sure that's the lyric. But if you were to search every transcript of HR Besties, I never could think of that word on the fly. That's these federal judges, they got their stuff together, obviously.
Love.
But I will say this, and we'll talk in a second. But one thing, all this stuff of like, this is, slanted and things like that. Criticism of best practices of someone that is a best practice organization.
Creator of best practices.
A creator of this is fair, and it is, from our perspective, the right thing to do. Just on our episode last week, talked about when we did things, we've made mistakes at work. Nobody's perfect, but it is important to spotlight these things. I have gone to great lengths. I don't go through the docket because I'm like, sure. I'm like, it has become like, wow, this is really notable. And there's so many missteps. That's why I made a really long YouTube video with timestamps last year on this, because there's so many lessons here. But also, people don't tend to see a peek of this. And part of what we do in our podcast is talk about experiences at work, talk about HR, but also really what goes on in these lawsuits. And so I actually take personally very seriously to not, skew or misrepresent things. I take great care to do that and talk about what's in the docket, again, because something's in a declaration that somebody says, that could be their perspectives. But we have repeatedly cited from that. I have paid a very hefty Pacer bill, and I've ponied up for a very hefty pacey, but some of the things that really I don't care for, that we'll set the record straight on the podcast, is I reached out to plaintiff's counsel to ask that question, literally, whatever was said. But I don't even need to pull that up, because because I actually also emailed this same attorney for SHRM that was making this argument in federal court and had said, hey, I'm one of the co-hosts of the HR Besties podcast. Same. We've been covering the lawsuit in Colorado District Court. We want to ask for any comment on the status of the lawsuit and whether it's been resolved or whether it's still proceeding to trial in November. Thank you, Ashley. That's it. Like, we're just trying to get the comment. And so first of all, I got that, did not get a response. We also reached out. I also, on behalf of HR Besties, reached out to SHRM's PR, just asking generally about the status of the lawsuit and about some of the things that we've heard from comments and in messages from those at SHRM, because we also want to give them an opportunity to be like, no, you got this wrong. And so anyway, we reached out to plaintiff's counsel to literally ask if the trial was continuing. We have not had some secret, troubling, back and forth communication. Our role is not to get involved in a lawsuit. It is to shine a light on something that a lot of employers, a lot of managers do on a day-to-day basis. And it's important to have accountability for that. And if we didn't cover it, to me, we wouldn't be doing the job that we want to do on the podcast. So that's something that I think is very important to clarify.
And it's especially important to people like us because SHRM claims to represent us and our chosen function, field, profession. And, they poise and posture themselves as this leading, organization on all things work, right? And they should be held to a very high regard because of that, right? They should be held accountable. They should have the light shown on them when they're doing things great, and especially when they're not doing things so great. So I think that's really, really important because this is very personal to us and what we do. And they really set the tone and the reputation for our function. And it's troubling, quite frankly.
Did you all have SHRM bringing up the HR Besties podcast in a federal lawsuit in your 2025 bingo card?
No, but I'm honored.
I did not, but it's fucking iconic. Are you kidding me?
Mm-hmm.
Well, from the legal perspective, wow, what is someone supposed to do? I talked this over with my mom, who's, of course, went to law school later in life. So she was like, oh my goodness. But so I was like, that's so interesting because they'd filed a motion in limine and things like that. And I was like, I bet they didn't file a motion on the docket because they were like, oh, we would have seen that straight away. I wonder if that's why they filed an oral motion. We'll see. But of course, we have the transcripts. We can see this. But also in it, just like we just found out yesterday in one of their episodes, they talked about, we had not talked about voir dire yet. That was I made a TikTok on the HR Besties about that. So it's also some clarification if you feel like you missed one. No, we're covering that this week.
Stay strong, plaintiff. I don't know them. I've never talked to them. Let the record show, but I love a justice warrior. I think it's time. I think good change can come from this big time.
It'll be interesting to watch the docket. I've got my eye and my debit card on the docket. So
can't wait to see you in Colorado. It'll be good, right?
It'll actually probably be really boring because a lot of lawsuit things are really boring. But
I know.
just to set the record straight. But some of the stuff, but just, again, to hear our coverage is all about shining also a light on things that can really happen at work and can even happen to, the biggest HR organization in the world. So learn lessons from others. That's something that, we don't always do enough.
It's how we get better, right? Damn. Best of luck to all involved. And bless that pacer, Bill.
It doesn't need blessings. It's like a gremlin. Grows overnight.
Feel free to Cash App or Venmo Ashley.
I know, right?
You can say it's for a drink because we're going to be in Vegas when this airs.
That's true. We'll be together when this one airs. That's true.
In our traveling t-shirt.
Oh, gosh.
Hey, Ryan Reynolds here from Mint Mobile. Now, I don't know if you've heard, but Mint's premium wireless is $15 a month. But I'd like to offer one other perk. We have no stores. That means no small talk. Crazy weather we're having. No, it's not. It's just weather. It is an introvert's dream. Give it a try at mintmobile.com/switch.
Upfront payment of $45 for 3-month plan, $15 per month equivalent required. New customer offer first 3 months only. Then full price plan options available. Taxes and fees extra. See mintmobile.com.